Hello, if we could prepare to come to order. Uh, According to one of our clocks, it's 10 a.m. and it agrees with my watch, so we will open the public hearing for HB 463. The hearing is open. Is the sponsor of the bill present? Excuse me? Thank you for the reminder. And we will, of course, begin our meeting with the Pledge of Allegiance. I'll ask Representative C to lead us in it, please. Thank you so much. Okay, we will now open the public hearing on HB 463. Do we have someone here? It looks like we do, Representative Werry, to introduce the bill.
Yes, thank you, Mr. Chair. Just a moment. The sponsor has another commitment during this time, so I will be introducing that for her on her behalf. I'll just read her testimony. For the record, my name is Representative Robert Werry, and I'm from the great town of Hudson, New Hampshire, Hillsborough District 13. So I'll be reading this testimony on the Board of Recount for HB 463. HB 463 is a straightforward bill designed to strengthen trust in our local election recounts by addressing a potential conflict of interest. I suspect that many of us have seen the professionalism of the state's general election recount firsthand, efficient, impartial, and well observed. But how many of us have been part of a local election recount like those for town or school ballots? Here's what this bill hopes to improve. Right now, under current law, the same board members who write up and recommend the warrant articles, such as school budgets, also serve on the recount board for those very same articles. The overlap risks undermining confidence in the process, even if no one intends any harm. Let me share a quick example. During a recount that Representative Cullum petitioned for a school district budget article, she watched two school board members miscount votes by marking them in the wrong column. Honest mistakes, perhaps, but they required repeated corrections. Worse, one of those board members kept blocking the observer's view, forcing the teams of observers there to double up just to keep things transparent. So this is not to point fingers or suggest bad faith. I believe that most involved in these recount processes are good working people working hard for their communities, but one shaky recount can spoil trust, and this seems to be an oversight in the statute. HB 463 offers a simple fix for town ballot recounts. The school board and other impartial folks appointed by the moderator shall make up the board of recount. For school ballot recounts, the select board and other neutral appointees make up the board of recount. No overlap, no conflict, just fairness. This isn't about politics, it's about practicality and protecting what we all value, a system that works well like we all want it to. Hope this committee will see HB 463 as a small fix and a common sense step to deliver confidence in the local recounts that occur on occasion. Thank you for your time and consideration. That closes her testimony.
Thank you, Representative Werry. Will you take questions from the committee?
I will try.
Thank you. I see there is a question, Representative C.
Thank you, Mr. Chairman. Thank you for taking my question. What happens if there's if the Board of Selectmen are not in the same district as the school board, or I should say the school board encompasses more than one town?
Well, it's my understanding that the recount would be in that particular locality, and so it would be applicable to that locality. And then it's the matter of combining or collating the different any recounts that would occur across the different voting wards. So this is for a particular ward, I believe.
Are there other questions from the committee? Seeing none, thank you very much, Representative Wary. I have a request to testify from Deputy Secretary Erin Hennessy. Thank you very much for being here.
Thank you, Mr. Chair, members of the committee. My name is Erin Hennessy. I am the Deputy Secretary of State. And I just want to point out, I believe the sponsor of the bill or the person who introduced the bill noted, but this would change the way we do recounts right now, and it would require a select board to take part in a recount of a school board election and a school board to take part in a recount of a select board election. So it's something that is not done currently, and it's something that I just want to make you aware of, that this is what this bill actually does. I'm happy to take questions if you have any.
Okay, thank you. Are there questions from the committee? Representative C.
Thank you, Mr. Chairman. Thank you, Secretary, for taking my question. Would this, do you feel that this would entail more legislation than what's in the bill?
Thank you for the question. I think it may. I would have to discuss this with our legal staff member. My concern would be with regards to your earlier question of the sponsor with school boards that are across multiple towns and what that makeup would be, and if it would require a member of a school board that's not in the town to conduct a recount of a town's election.
Further questions from the committee? Seeing none, thank you very much for your testimony.
you.
I have no further requests for testimony, so seeing that, I will adjourn the public hearing. And thank you for the blue sheet, Representative. Okay, the public hearing for HB 463 is hereby adjourned. Our next public hearing is scheduled for 10:20. On the blue sheet, we have one person testifying that they're in favor of this bill. And I do not have access to the online testimony. If one of my colleagues would care to. Okay. All right. Well, thank you very much. You can let me know and I'll announce it when I have it. All right. So we will come back into session for a public hearing at 10:20 a.m. for HB 420. So we have 15 minutes here.
Quick, I have that number for you from the online testimony.
Okay.
Supporting is 13, opposed 7.
Thank you very much, Representative Newsom. Yes, hello everyone. I've just been informed that we have a Dartmouth Civics group here today joining us in election law. And I'm sure we're all very pleased to see you, and we hope your time with us is not only instructive, but very interesting. Thank you for being here and for your interest. We really do appreciate it.
Okay. Did you do the pledge? Did you do the pledge? Okay. All right. We're back. Going to open up the public hearing for House Bill 420. Nice, well, relative to the chain of custody for ballots. I'm going to recognize representative. Do I have a representative for this bill? Is he here? Okay, that's not usually not a good sign. Let me pull up the bill real fast. 420. Okay, a lot of stuff comes up when you put in 420. All right. Representative Toner, can you do us the honors of introduction for introduction for purposes only? And let's see what we've got. This might be the shortest hearing we have all day. Representative Toner, welcome to election law.
Thank you.
Introduce 420, House Bill 420.
Representative Travis Toner. I represent the town of Belmont. And I'd like to introduce House Bill 420 relative to chain of custody for ballots. And I will not be taking any questions.
Awesome. I only have one pink card. It's Deputy Secretary of State Aaron Hennessy. Deputy Secretary, you're recognized.
Thank you, Mr. Chairman. Good morning, everyone again. Erin Hennessy, Deputy Secretary of State. This bill should have a fiscal note attached to it. I don't believe our office was contacted, but we had a similar bill last session. I just want to give you a heads up that this, because of the amount of time that you have to keep ballots, we would have, I believe it would probably cost between $15,000 and $20,000 a year for our office if we wanted to purchase sturdy, reusable containers. We did do a pilot program in the general election with some of these containers. I would say that they are not the ideal container because the bottoms are not flat. So we had to put some cardboard in the bottom so that the ballots wouldn't fold if there was a recount. But I will say that the town that did use them, I believe it was Sanborn, ended up purchasing them for their local elections because they found them easy to use and not having to use the red tape. They appreciated that. If you were to go down this route, I just wanted you to make you aware of the fiscal aspect of this and also ask you just to clarify exactly the language that's in the written in this legislation. Reusable security containers. I'm not quite sure if you want to describe what you mean by security. Locking containers. Is it a container that self-locks or is it a lockable container? For the serialized proprietary sealers, our sealers right now are not serialized. They are a sticker with our seal on it that we do not have serial numbers on. We distribute them to local towns. They require the signatures of the clerk, the moderators, and the select board members, and that's what makes them a security aspect of the seals themselves, but they are not serialized. So I would just like clarification. Are you looking for serialized actual locks on the containers, the containers to be lockable or locking themselves? And the frangible paper seals, I'm assuming that means the seals that we're already using, which are you can rip with a knife. And then finally, the last part of the bill deals with custody of the boxes. Right now, when a recount is requested, or if we do an audit of state election ballots, our Secretary of State's office goes to the local town clerk. The clerk will put on their security log for the boxes that they are signing the boxes out. They will not be returning, and they're going to the Secretary of State's office. Our office also has a log for the boxes we create where we say this is when we picked it up, where we picked it up from, how many boxes there are, and so forth. There is not, once we take custody, that is the log of when we've taken custody. There's no other parts of custody of what we do with them and who, and so I believe that the last page of this needs some clarification because once we have custody of it, and there's not different times and dates of our custody of the boxes. So I'm happy to take questions.
Are there questions from the committee? Representative Wood.
Thank you. Thank you for taking my question. You said that this one town tried it. Do you remember or know how they locked the boxes?
Sure. Thank you for the question. So it was a plastic container. We got red ones for the ballots, blue ones for absentee materials, very similar to our cardboard boxes where we use. They kind of closed like this. And we put the paper sealer over the top, and then the one of the seals that we use for the AccuVote device or the Voting Works device, where it has a number on it, so they write down on the actual paper sealer the sealer that was used to lock the container.
Representative Muirhead.
Thank you, Mr. Chair. Thank you for taking the question. In your judgment, do you think that replacing our current containers with the kinds of containers proposed in this bill would improve the security of ballots after the vote?
Thank you for the question, Representative. I don't have concerns over the security of the ballots. We have had some questions previously where others have concerns because just the way the cardboard boxes look, we do request that they reuse ones that we've mailed to them with the ballots in it. So unless it's a brand new fresh cardboard box that has not been taped before, it's not going to look the same as a box that has been reused with the red tape over it and then a new sealer put on top of it. So the appearance, I think, would be better for some people that don't trust the security, but I personally do not have concerns with the current security.
Yep, follow up from Representative. Oh, actually, Representative Toner's up. I apologize, Representative Wood.
Thank you. I just had a question of who has control of the seal tape and whether it's at the town or at the SOS office.
What of the seal tape?
The security tape or whatever is used to seal the boxes to make sure that like they know if they've been opened or tampered with.
The red tape.
Yeah.
Okay. So right now, the way we suggest that people seal their boxes is that they seal them with packing tape, a strapping tape, and a red security tape. We've tested them, and we distribute the red tape out to the local clerks. So between our office and the clerks, they are the ones with the access to the tape. The tape is not, in my opinion, 100%. It is very sticky, and red stuff can get all over your hands when you're using it, but I think that the clerks do a good job using it.
Further questions, Representative Lane?
Thank you, and thanks for taking my question. What does the serialized tape, I mean, I guess I'm not familiar with serialized tape, and what would it do or enhance to this project?
Thank you for the question. That was my question, as I just wanted clarification on what that meant.
Representative Weary?
Thank you, Mr. Chair, and thank you, Deputy Secretary, for taking my question. With regard to the paper containers or cardboard containers that are currently used, have you seen incidents where they've been stacked too high and collapsed or things like that? And there's, so the question is more, is there an inherent benefit of having better containers because of the possibility of either over time deterioration or stacking and you have a collapse of the boxes?
Thank you for the question. Yes, we have seen instances where a seal, a corner of the cardboard has broken because it was dropped or something, and it doesn't have anything to do with the tape, but the box integrity itself. And I think it might have to do with how much recycled paper is put into cardboard boxes these days.
Representative Wood.
Thank you, Mr. Chair. Thank you for taking my question. You said that you've seen the boxes and they probably haven't looked pretty. I'm not trying to put words in your mouth, but I'm just trying to figure out that, do they look secure to you? Even though we're not looking for pretty, but do they look like if someone went in or out, you would know it?
Thank you for the question. So I haven't seen every single box there is, but of the boxes that I have seen at polling locations, when I'm there to observe them being sealed, or the ones that we do see at recounts, I haven't had any personal concerns with them. They do look sealed.
Thank you.
Representative Toner. Trying to go in order here.
Are you familiar with the process of securing evidence and chain of custody? Is that possibly what this is trying to duplicate?
Thank you for the question. No, I am not.
Representative Muirhead.
Thank you, Mr. Chair. Thank you for taking the question. Curious, do you know if there's a standard, common practice among the 49 other states that hold elections, that administer elections for storing ballots? Are cardboard boxes the norm? Or is there a certain type of ballot box that everyone else is using?
Thank you. So I did reach out multiple times to my colleagues across the country to find out what they use, because I am trying to find the perfect container for our ballots without making it too heavy, so that people can pick them up and stack them, put them away and store them. I haven't found a standard one. There was stackable containers that were previously used in Maine that may still be used in some Maine locations that are metal. I don't know that I would recommend going to metal. It just seems a little dangerous and heavy. But I have not found a standard one. So if somebody wants to create a business, I think that might be a good idea.
Thank you.
Representative Weary.
Thank you, Mr. Chair. Thank you for taking my question. With regard to the serialized aspect, I think perhaps what the sponsor was trying to get at is, can each individual box be specifically identified? And how is that handled now? Maybe that would help the committee understand that aspect of this bill.
So I will say that our cardboard boxes are not serialized. How it's handled now is that the labels on the box, on the paper sealers that we use, are supposed to be labeled box 1 of how many. So if there's 20 total boxes for the election, the first one should be box 1 of 20, 2 of 20, and so forth. So that's how one would know how many boxes there's supposed to be for that election. And then the clerk will put that on her log, the boxes that she is or he is maintaining in their office securely.
Further questions? Seeing none. I don't have any other pink cards. Representative Gosowski, if you could grab me the blue sheet online. This hotly contested bill, HB 420, had 6 in support and 7 opposed and 0 neutral. I think we asked more questions than people testified online. And then on the blue sheet is blank. So it's having no other pink cards of members of the public wishing to speak, I'm going to close the executive session on House Bill 420. The committee will stand in recess until 10:40 for House Bill 492.
It's 10:40 and it's time to open the public hearing on HB 492. And I see the sponsor, Representative Horgan, and you are recognized to introduce your bill. Your preference.
Yeah, we're just gonna leave it on the table. That's fine. If it's passed around, that's okay. It won't affect,
All right, so Representative Horgan, when you're ready, thank you for being here.
Well, thank you very much. I'm Resident Timothy Horgan from Stratford County, District 10, the town of Durham, the home University of New Hampshire. And actually, I'm a former resident for about 5 or 6 years in Hanover, and I see a group of Dartmouth students, and Dartmouth is a great school. I mean, it pains me to admit that because I myself went to a rival school, Columbia, but it was a good natured rivalry. Now, if we had a crowd of students from Princeton or Harvard, well, I guess I would still be glad to see them too. So this is HB 492. It's basically about recounts when you have write-ins after a primary where no one has filed to run. So we had an incident which happened last year in my county, which is Stratford County, during the state primary on September 10th, 2024. So the Republican Party had no candidates for the District 3 County Commissioner race. And actually, there have been many bills in this House related to the Stratford County Commissioner districts, most of which, though, happily for you people, have been in municipal and county government. But anyway, nobody filed for the District 3 County Commissioner race. And so no one filed during the June filing period. No one was chosen to fill the vacant slot on the primary ballot immediately after the filing period, which parties can do. Also, nobody stepped forward to run a write-in campaign. However, a Democrat did get enough write-in votes on September 10th, 2024. This was longtime County Commissioner George McLaris, and he was unopposed in his own party's primary. And I guess in the interest of full disclosure, I did vote for him, and I'm a longtime friend of his. And anyway, he got just barely enough votes, 35, to be listed on the Republican column in the general election. And there are only 20 other Republican write-in votes in the September 10th primary. I think they were all tallied of the sort which they tallied as scatter. And a document I don't have with me, but which I know where the Secretary of State's office could provide you, is the tally sheet from the county, the tally sheet from the towns and city, and there's some city wards in Dover and Rochester, which are in Stratford County Commissioner District 3. So that might be a useful piece of information, because I think the Republicans had some doubt about whether or not they were accurate. I guess I'm satisfied they were accurate, but those things are written out by hand, so sometimes a little bit hard to discern what exactly it is they're saying. But so Representative Kelly Potenza, a Republican from Rochester, on behalf of the Stratford County Republican Committee, asked for a recount, but she was turned down both by the Secretary of State and the Ballot Law Commission on the grounds that she had no standing to ask for such a recount, since she did not run for county commissioner as a write-in candidate. I guess that would have been legally questionable, because she's also ran for state rep and was reelected easily. But anyway, so she wasn't qualified to ask for a write-in candidate. Under the current law, the county committee had no standing, and the state committee didn't have any standing. In fact, there really wasn't anybody who had standing. Now, Commissioner McLaris, if he had hypothetically gotten 34 votes in the initial election night count, could have asked for a recount. And so, the Stratford County Republic's desire for a recount was understandable. I could probably understand if this had happened to a Democrat. Although, of course, they certainly had several opportunities to, stop this from happening. They could have convinced somebody to file. They could have named somebody in June when they had the opportunity. They could have also talked somebody running a write-in campaign, but they didn't do any of these things. But still, their displeasure with the situation was understandable. So what this bill does, if passed, it henceforth allows the state party committees to ask for recounts for situations similar to the September 10th, 2024 District 3 County Commissioner race. And think there actually have been some recounts of write-in candidates in other races. Although even though Commissioner McGlaris was not popular with the Stratford County Republican leadership, he actually was pretty popular with the voters. Almost, I think what it says in my testimony, almost 90% of the voters in the county commission, their district voted for him. So there were about 23,000 votes for McGlaris in the November general election and only about 3,000 undervotes. So, I mean, even though he was a very popular candidate with Republicans, Democrats, and Independents alike, I can still see a situation where it might have been appropriate that let somebody have a recount, and so this would allow the state parties to do it, and they would pay the usual costs for a recount. And there's a whole procedure in the law, as you probably know better than I, for estimating the costs and collecting the money from the party committee. So that's my bill. I think it's a fairly simple change. It's a bipartisan bill. We need a little bit more bipartisanship around here, so I urge you to pass it, and I'd be happy to take any questions.
Okay, thank you, Representative. Are there any questions from the committee? Representative Lane.
Thank you, and thanks for taking my question. What happens if the person is an independent? So I guess they wouldn't have already been on the primary ballot if that happened. I thought of that as you were talking, but it might not come up.
I wish I thought of that before I was talking. I do know that you have to be registered as a member of a party to file in a primary. I believe you can actually be nominated in a primary without being registered in a party. And I know there was a write-in for state senate this last cycle with Michael York, who's a state librarian. He used to work right across the street from here until he recently retired. So he wanted to run as a Democrat for his state senate seat, and he was turned out he's a registered independent, but he did run a write-in campaign, was successful, and did shown as a Democrat on the ballot. I don't know specifically whether he changed his party registration during that process. So there have been cases where independents have been nominated through a write-in in the primary. So I know. So hope that answers your question as best I can. So that might be something you can look at in a work session if you want to have it.
Are there other questions from the committee? Oh, yes, Representative Bay.
Thank you, Mr. Chair. Thank you, Representative Horgan, for taking my question. I'm curious, in this your statement where you had a hypothetical that had Commissioner McGlaris gotten 34 votes. He had a standing to ask for a recount. By what statute is that?
I don't have I have the printout of the statute here, but it's somewhere, I believe, in RSA 660, post-election procedure, I believe. So I sort of have this answer possibly at my fingertips, but anyway, so that's there's a whole law about the recount and how, depending on how close it is, like whether you have to pay for it and so forth. So I'm probably not the best person to ask, and so unfortunately, the Deputy Secretary of State stepped out, so she would probably be more likely to have the answer at her fingertips than I do. But yes, but people have asked. There have been recounts in write-in primaries before, so it does happen on occasion. So.
Any other question? Follow up, certainly.
Thank you. So could you just tell us what it says, even if you summarize it in your own words, like?
Well, the recount. Well, depending on how close it is, and this applies, I think, even to a write-in candidate. If you're within a certain margin, and that depends on the number of votes in the election, you don't have to pay a fee. I myself had to survive a recount in a primary to a citizen, to a rival who was actually filed to be on the ballot, and then if it's outside of that, then I think there's a sliding fee scale, and then if you're totally, if you're like totally outside the parameters, then you have to pay for the cost of the recount. So you have to pay for all those people to like hang out and do their thing at the state archives all day. So which a lot of the secretary, a lot of the people who are actually doing the counting are actually paid a token amount to do it. So there's some cost to it, and the Secretary of State will estimate that, and then you can decide whether or not you want to go forward with it. So usually the process is very accurate. So there's usually not much point in asking for a recount unless you're within a very few votes of either very few votes of winning. There's usually no point in asking for a recount, but you can if you want. It's a little bit different with the write-in. That's a little bit more ambiguous because the clerks have to make a judgment on what constitute a vote for a person and what didn't. So, like, I know, for example, I think with the McLaris race, there's some people who, I mean, it seems like a pretty simple name. It's spelled phonetically, and everybody in Stratford County knows him. But I guess there may have been a few people who didn't spell his name consistently. I know in the First Nation presidential primary, we had like a lot of write-in votes for Biden. I know, like I for some reason decided I should write Joseph R. Biden instead of Joe Biden, like all the other people in Durham did. But they decided to count my ballot in the Joe Biden column, even though I'd written Joseph R. Biden, because they knew that was the same person. But kind of, hopefully that answered your question. Somewhat longer answer than I probably needed to give. But
Are there other questions from the committee? Yes, Representative Newsom.
Thank you very much. And thanks for taking the question. What is the standard of uncertainty? Is it 30? Is that close enough to 35? Is 40 too many? What do you mean by uncertainty?
I don't actually, I don't have the specific number for that. That's probably, but it's certainly in terms of the fee schedule, it's by the number of votes that you have. So certainly, if you didn't get any write-in votes, it would be absurd to write for a recount. If you got, say if you got 34 votes, it would be reasonable to ask for a recount to make sure you in fact maybe picked up another vote that they missed somewhere, or also. And also, you can tell sometimes, and also you can see by the write-in sheet, sometimes if they wrote down a name that you think should have been yours and wasn't yours, say if somebody written, like, I don't know, John McLaris instead of George McLaris, George could have like asked to have that counted as for himself. So that's more of a question for the Secretary of State's office, and the Deputy Secretary of State stepped out of the room, but I'm sure you can get an answer to the question from them. So,
Further questions from the committee? Not seeing any. Thank you very much, Representative. Not seeing any other pink cards indicating a desire to testify or anyone appearing to want to testify. Representative Guzovsky, would you get the blue sheet, please? And can you look up the online?
Yeah. Online was 99 in support, 1 opposed.
And I see no input on the sign-up sheet for testimony. So with that, I will close the public hearing for HB 492. The next hearing will be at 11 a.m.
Okay, it's 11 a.m. So we'll open up the public hearing for House Bill 574, requiring background checks of the private companies and their contractors who program and maintain New Hampshire voting machines. And we'll recognize our own Representative Burnham for the purpose of introduction. And without objection, Representative Burnham will be allowed to return to her seat to conduct her clerk duties after her testimony.
Thank you, Mr. Chairman and fellow committee members. I am Representative Claudine Burnham, representing Stratford District 2, Milton, Rochester Ward 5. I am introducing HB 574 FN, requiring background checks of private companies and their contractors who program and maintain New Hampshire voting machines. This is essential to our election integrity process. We want to ensure that our ballot counting devices are being maintained and programmed with the utmost security. And since the machines are programmed and maintained by company employees, it is only right to have every person involved in this process to pass a level of security with a background check. These machines determine the winners of our leaders in our governments, and we want to ensure our voters that their machines are processed by vetted employees. This bill is attached with a fiscal note, and I'm not sure why, since most, if not all, companies contracted with the government require background checks for sensitive roles in national security, and since our federal elections are conducted on voting machines, I believe that would be grounds for national security. Even if the state believed they were required to pay for background checks, LHS Associate employees between 11 to 31 employees, and Voting Works employs between 11 to 50 employees. Not all employees program and maintain the voting machines either, so this number can potentially be much lower. The average cost of a comprehensive background check is about $50. The most this would cost the state is about $4,050, not the $250,000 and $500,000 that is estimated in this bill. Most employees only need one background check at the beginning of employment, not to be repeated every year. And from what I understand, sometimes the background checks last a few years, so there's that possibility of reduction of costs. Even if it were the projected cost stated in this bill, we do also have HAVA funds that would certainly be able to cover the costs of this essential process for voter trust. This bill is a common sense bill with transparency, security, and accountability. Thank you for your consideration in voting this bill in, so our voting machines can be programmed and maintained by verifiable and trusted employees of LHS Associates and the Voter Works. Thank you.
Questions from the committee? Representative Lane.
Thanks for taking my question. I know he had his
I
hand
was
up too. I know. This is requiring that you put information, social security numbers and information on the secretary's website. Am I reading that correctly? It requires submission of the state, who will then make the information publicly available to the Secretary of State's website. I'm reading the methodology on the back, this summary. Yeah.
Oh, I didn't see it.
Yeah, it's right. Somebody said line 11 on page 1.
That's not the part that I believe that's been addressed in this RSA. It's just, I don't know. It just sends a list of current employees programming and maintaining electronic.
Can I follow up?
I don't think it has.
Yes,
Yeah.
follow
Yep.
up.
I think it's the identification number that we're referring to. And I don't know if that's right, employee identification number, if that's their social security number or what that is.
Yeah, I don't know what that number is. That wasn't in my proposal, so to speak, but I don't think that that's referring to a social security number, but probably more of a employee number.
Further questions from the committee? Representative Weary.
So last fall, it was discovered in the software code of the machines that the Ukrainian national anthem had been programmed in, and other cybersecurity bugs were also found. Do you think that the background checks might prevent this kind of nonsense from occurring in our New Hampshire election programming for our ballot machines?
I certainly think it's a possibility. I'm not a programmer, but I would hope that any type of background check would at least start the process of ensuring that security measure. So
Representative Newsom.
I'm just sitting where my name tag ended up, so thank you. On page 2, it says that the results of the background check shall be publicly available. Are you aware of any other required background checks that become publicly available?
I'm not well versed with background checks and what availability that there is on that. So I do not know. Thank you.
Follow up?
Yep, follow up.
If something comes back as sort of a positive hit, does anything in this bill prevent that person from working their job?
Not this particular bill. I would assume that would be a criminal issue or some type of, it would fall under another law of some sort, of some criminal activity.
Further questions? Representative C.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. On page 1, line 10, it talks about reports every month. Does that mean the company has to get a security check on each employee every month?
What line was that? Sorry?
Line 10,
Line 10.
page 1.
Well, it does say that. I wasn't aware that was actually written that way, unfortunately. But I'm not sure why.
Further questions from the committee? I have one. Representative Burnham, would you believe that I have to undergo a background check every 3 to 5 years to work in a child care center, and it costs $28?
I would believe that because I have been involved with children's ministry and other and in-town recreation where I've had numerous background checks each time that I started. And once that started, it was acceptable for 3 years.
A follow-up, would you also believe that that background check includes a digital fingerprinting that's sent through the FBI database?
Yes, I would believe that because I have had my hands digitally fingerprinted for that use.
Any other questions from the committee? Seeing none, thank you. I
Thank
don't
you.
believe I have any other pink cards. So Representative Gosofsky, if you could grab me that.
I thought of a question.
Oh, if you grab me that blue sheet. And on line 574 had 113 support, 11 opposed, and 0 neutral. On the blue sheet, it's not blank, so I got to look at it. Thought we were going to get a blank one. We had 2 people signed up against who did not speak. Having no other members of the public wishing to speak on House Bill 574, I will close the public hearing on House Bill 574, and the committee will stand in recess until 11:20. All right. We are 11:20. We're going to open the public hearing on House Bill 497, requiring the periodic evaluation of the forms and procedures related to performing voter checklist duties. And we will recognize our own Representative Weary for the purpose of introduction.
Thank you, Mr. Chair, and thank you, honorable committee members. My name is Robert Weary. I have the privilege of representing the great town of Hudson, Hillsborough, District 13. This bill is a simple bill, and it really proposes sort of a pilot type of study whereby the Secretary of State's office would periodically evaluate the forms and procedures for usability and determine resource and time requirements for the completions of forms and the performance of the procedures. In reviewing the RSAs, there's very few places that talk about how the forms and other procedures that are used by our election officials are handled by the Secretary of State. In RSA 652-22 for the election manual, it does say something to the effect of, or let me quote exactly, the manual shall be written in non-technical language. So that's the only place really that I've sort of found where there's a prescription for how procedures and forms are to be written. And the thought was there is this science called human factors engineering. It's used a lot in the medical device industry, which I'm very familiar with. And the aspect to it is that basically anything that is potentially complicated should be evaluated carefully and determine that the people who would be normally tasked with performing those duties are provided procedures and forms that evaluate their ability to use those forms, and that they can be used without too much complexity and any loss of proficiency in handling their those procedures. So the idea behind this bill is very simple. You just allow the Secretary of State to periodically evaluate the forms for usability. I started really with the checklist procedures because this is maintaining the voter rolls, to me, is one of the cornerstones to election integrity. And also we know from the experiences in the last general election that there were extremely long lines due to same-day registration in some areas. So it would seem to make sense that this could be an area that could at least be evaluated. So that is the essence of this. I'll happy to take any questions if there are any.
Other questions from the committee? Oh, there are. Okay. Representative, we'll just go left to right. We'll start with Representative Bay.
Thank you, Mr. Chair. Thank you for taking my question. When you say periodically, do you have a notion of the period? Because, you know, we can go to extremes of really short or really long. I mean, such that, you know, every 10 years is a period, every day is periodic. So what are you thinking about?
Ideally, I think most often usability, just speaking from medical device experience, most often usability is a big initial evaluation, and then it's minor periodic reviews that occur typically with updates to procedures. So if we had a change in the law, then there would be an evaluation of the usability and how that is impacted. Or how the procedures and forms are impacted by a change to the RSA. So that's the kind of nature of how it's done in at least other industries. So I would expect the periodic is based mostly upon RSA changes, but it, you know, on occasion it might be a multi-year cycle. So 3 to 5 years could be also another standard that could be used in that case.
Representative Gilmore.
Thank you. It's pretty much the same question, but I'm actually looking for a definition of periodic, if that could be possible, and something to think about in terms of, because again, I'm up in the air what it means. And you explained something, you know, just prior to this. And maybe if you could put it in writing in some manner, that would be, because I don't know how, excuse me, I don't know how the Secretary of State or other people would interpret it. So I think there should be greater clarity, if that's possible.
Thank you for your question. I think it could be perhaps amended to something along the lines of evaluated at least every 5 years or sooner if necessitated by changes to the RSA. Would that be suitable? We're going around the table, so.
Yeah. We gotta go to, well, we'll go to Representative Newsom.
Thank you very much. Thanks for taking the question. Do you know what the Secretary of State's office does now, even though it's not in a shall language like your proposal, but are they reviewing the forms and procedures at this point?
I would say certainly that there is some review of those. I do not, just in basic discussions, not perhaps specifically about this bill, but in basic discussions, there is no one who has human factors engineering background, or another parallel thing to this would be industrial psychology. So there is no one who has sort of that background, to my understanding, reviewing these forms and procedures at this time.
Representative Ward. Oh, he got you? Okay. Further questions from the committee? Seeing none, I don't have any. Thank you, Representative Weary. I don't have any pink cards. So Representative Gazowski, if you could grab the blue sheet, and online we had, I don't know why I clicked off of it. That was not very smart. 74. And the blue sheet is blank. Oops. Okay, we'll grab it. And then 497 was, where's the summary? Hold on, let me refresh it. It's not a hotly contested bill, but I want to read they're not showing the summary anymore, which kind of sucks. It was like split, but it was like 7 and 8. I can't count it up without the summary, so my apologies. I don't know why the summary is not working. All right, with that, we will close the public hearing on House Bill 597, and we will stand in recess until 11:40.
Mr. Chair, on my computer, it says it was 4 in support, 9 opposed on the summary for 497. Thanks.
It is 11:40, and it's time to open the public hearing on HB 514 FN. This public hearing is now opened. I recognize Representative Berry to introduce the bill he has sponsored.
Thank you. Yes, my name is Representative Ross Berry. I represent Ware, the towns of Ware and Goffstown. I'm here to introduce 514, allowing private persons to sue for violation of election law. So this came about in a lawsuit that I filed with a state senator in regards to what we viewed as an abuse of in one of the sections of RSA 659. And the last clause of RSA 659 mentions the Attorney General and the enforcement procedures for the entire chapter. And what the court took the position that only the Attorney General can basically adjudicate a violation of 659. So if the Attorney General's office, the Department of Justice, deems that there's no violation, you as a private individual have no recourse for any part of the chapter, which is actually really dangerous. So the first thing is I believe you have a right as a citizen to seek redress from your government. And one person should not be able to determine whether or not you get to seek redress. And there's all sorts of things in 659 that both sides of the aisle should be interested in the potential to be able to file a lawsuit in court over. For instance, if you are denied the right to vote, and the court takes the position that only the DOJ can pursue a violation of 659, and court takes that position, you're done. That's it. You don't get to vote. In my case, I was suing over an electioneering issue, which is also under 659. But 659 handles election procedures. So if you see something that's a gross abuse of the process and the DOJ disagrees with you, one person the DOJ disagrees with you, it's over for you. You don't get to seek redress. So this is an attempt to allow private individuals, if they don't believe they've had their concerns redressed by the DOJ, to bring a lawsuit into court. It does have in there some qualified immunity protections at the very last section, so we don't have that kind of chilling effect on suing a person on the personal level. But that is the intent of the law. That is it also has a provision, I should say. It has a provision about if you suspect that RSA 659 is being violated, the first thing you have to do is go to the DOJ. And the DOJ has 5 days to say, hey, yeah, something's wrong here, something's not wrong here. The exception being is if you're within 2 weeks of an election, so 15 days of an election, and then you can go straight to court. Because obviously, if they're delaying, if the DOJ is delaying, you should be able to seek redress because the immediacy of the matter requires you to go around them. But so I try to create a framework of first you got to go to the DOJ if you're really close to an election or on election day and you see something's going on that's wrong, you should be able to go to court and seek redress. So with that, I'm happy to take questions.
Oh, thank you. Are there questions from the committee? Representative C?
Thank you, Mr. Chairman, and thank you for Representative for taking my question. Or should I call you Chairman?
I'm representative right now. Although I may try to do the thing where I say who's president.
Does this mean that you have to go to the DOJ first, and only if they deny you that then you have standing to go to court?
No, so you have to go to the DOJ first and let them attempt to act, right? Because they may solve your problem, right? The DOJ may solve your problem, and then you don't need to go to court. So that's the intention. Is you go with the exception of the 2-week window. You got to go to the DOJ first, which is the procedure now, at least as what the courts have said. But if you don't like what they do, or they say there's not a problem, or they say they're not going to act on it, and you feel that you're being violated, you're suffering harm, then you get to go through the court system. And this includes things like registering to vote. If your moderator denies you a ballot and you feel that you should be able to ballot, and they won't let you fill out, a challenge voter affidavit or something like that, some sort of relief mechanism that we've built in that may or may not be there anymore. But this allows you to kind of seek relief through the judicial system, which you're supposed to be able to do. You're supposed to be able to seek relief through the judiciary. And for some reason, the judiciary has recited that, no, you don't get to do that because of the very last line in RSA 659, which they have interpreted that says only the DOJ, the Attorney General, can push claims of RSA 659 through the courts.
Thank you. Are there other questions from the committee? I see there are. Representative Muirhead first.
Thank you, Mr. Chair. I'm trying to figure out at present, you mentioned that there's something in 659 about how the provisions of election procedure are enforced or how violations are,
Yeah.
I guess, prosecuted, and I haven't been able to find that.
It's the very last section, and it mentions the Attorney General's office. You'll see it. So I think it's the second. It's the last. I don't have it in front of me, but it's the last. It's the last little section. And I think it's section A. I think there's a two-part section, A and B, and I believe A is the one that mentions the DOJ or the Attorney General's office. I don't have it in front of me, but it's in there. And the courts have interpreted that as being only the DOJ can pursue the violations of 659.
Representative Wood, do you still have a question?
I do.
Please,
Thank you
go
for
ahead.
taking my question. You mentioned that you've had a personal problem along these lines. The way the law was written, was it intended to be that way, from your understanding about basically there being a last stop as far as the result?
I don't know. I haven't looked into it. The answer is I don't know. My full response would be I don't care, because I believe at my core you have a right to go to court. You have a right to do that, and you have a right to seek redress through your government. And I fully reject the idea that one person, the Attorney General, gets to make a determination, and that's the end of it. And you can suffer abuse. And you could see how that, and I'm not claiming, I obviously with my particular case, I disagreed with what the DOJ's determination was. I wasn't quiet about that, and I still disagree with their determination on it. But when I went to go seek redress to the court, I was able to make my case to the court, but the court ultimately said it doesn't matter if the judge agreed with me or not. Only the DOJ gets to make this determination because of the language that's in RSA 659 in the last section.
Thank you.
And I just disagree with that premise. And that could happen at any point in that section. So there's stuff in there that my friends on the right like. There's stuff in there that my friends on the left like. One person could get in there and just be like, no, I'm not enforcing that today. Or they could do disproportionate enforcement, and there's nothing you could do about it.
Further questions from the committee? Okay. Representative Lane? Representative Lane, go ahead, please.
Thanks for taking my question. Sorry. I was looking at the attorney's fees section.
Yep.
And it's on page 2. It says that no attorney representative shall charge or collect fees for legal services rendered unless the fees have been approved by the Superior Court.
Mhm.
So how do you then hire an attorney to get you into court before they've had their fees approved?
Yeah. I mean, my goal here. So the answer is you can't, right? That's built in the law intentionally.
Yeah.
I don't want this to be a cash grab. I want this to be there's harm that is occurring, and you as a private individual need to be able to go. You can, as you know, Representative Lane, you're an attorney, you can file pro se in New Hampshire court. And if you think you have a good argument, you can make it, but no, you can't. We're not going to be sitting here padding up the pockets of attorneys. And because you can imagine there's a lot happening in 659, there's a lot of moving pieces there. And things happen by accident. Some things happen by accident. Some things happen by intention, right? And that's why we have the relief valve at the very end for things that are accidents or not a big deal. But I don't want to open up a floodgate of lawsuits, and I don't want attorneys encouraging said lawsuits because they think that it's a payday coming. I want you to be able to seek redress through the judicial system, which I go back to, is your right.
I'm going to proceed with Representative Muirhead first, and then you can have your follow-up. Thank you.
Thank you, Mr. Chair. I'm also trying to just ascertain the nature of the lawsuits that would be filed. So these are civil suits. There are individuals being harmed by a violation of election procedure. Are they charging the state with harming them? So the state would be the defendant in every case? Or are they charging individuals who are working in the polls with harming them?
So there is a section, I believe it's first page. I believe there is a section of that. Excuse me. Let me find it. Here we go. It's second page, line 12. Claims filed against state and its agent. That goes into the details of that. And what that talks about there is basically the state. The state is the first kind of person. But if you try to go after that person on an individual level, it's very easy for them to drop off. I don't know if I answered that question well. But that section, the language in there to answer that is in this bill. That I don't want to set up a system where people are trying to sue their moderator, they're trying to sue their selectman. I don't want to set that system up. I want to set up a system where if you're being harmed, you can seek redress, and one person is not the gatekeeper to your ability to fix a problem. So I try to put a lot of restraints on it.
Representative Lane, you had a follow-up?
It's my understanding, and I don't know this about Superior Court, but in a lot of the courts, and I've been practicing for a while, but 50% of the suits are pro se. And actually, pro se people tend to, cases take longer. So my concern is that you are opening the floodgates for anybody who's not happy to file this pro se because they don't need an attorney. And so pro se is, I think you do, but you don't agree with that. You don't think having it pro se is going to increase the number of lawsuits?
I would never take the position that someone should not be able to file pro se, because I believe at my core, anybody should be able to go to the court and seek redress. And as to the immediacy of it, that's just kind of one of those problems with an election, right? It has a defined point,
Right.
has a defined point, has to happen. And I remembered I forgot to answer part of Representative Muirhead's question, so I want to
Okay.
go back to him real fast. He asked what type of suits would be filed. We're talking about TROs, temporary restraining orders, injunctions, that sort of stuff, to seek relief from the court. You know, if somebody's telling you can't vote and you believe that you can vote, and you should be able to go to a court, and if a court says yes, this person can vote, the court's going to issue a court order for you to go vote.
Yeah. I have one more follow-up.
Yes, go ahead, please.
It kind of pings off of Representative Muirhead's. In that situation where you're denied the right to vote, would you be suing the city or the town or the Secretary of State? Because the people that are denying you the right to vote are actually the town or the city, not the Secretary of State.
So in that case, you would go after the town, because they're the ones administering the election. Yeah, you have to be able to go after the person who's doing, or the entity that's doing the harm, right?
Representative Wary?
Thank you, Mr. Chair. And thank you for taking my question. I'm trying to kind of summarize this. So it's a fundamental right to petition the government for a redress of grievances. In your particular situation, you had an unelected official stop your ability to redress your grievances because they basically said, no, we're not acting on it. The courts then interpreted that as lack of standing and would not act on it.
Correct.
So you're now just kind of enabling standing in the case where elected officials are more responsible. Am I mistaking that? Or
You're enabling standing to go in front of the court and plead your case. Because in my particular case, they tossed out my case due to standing, and it's not about my particular case, because I've already solved my issue with that legislation. My issue is if there's other, when the court took that position, it scared me because now there's a gatekeeper for justice, and we have a Department of Justice. There's a reason for it, but if your rights are being violated, you should be able to go to the courts and have those issues addressed in a court of law, which has always been a fundamental
First Amendment.
It's a fundamental part of our process. You have a right to seek redress. And I just don't like the idea of a singular person being able to say no to that. You should be able to go through the court system. It's why the courts exist. They're the reason why we have three bodies. And I just don't think one person in the executive branch telling you no should be the reason why you just have to stop.
Are there further questions from the committee? Representative Muirhead.
Thank you, Mr. Chair. I want to just return to that attorney's fees section, lines 25 and following on page 2. And I just wonder about like this sort of hypothetical. Suppose that I think I've been harmed because election procedure hasn't been followed, and I being a lawyer snob, go out and hire an attorney who charges $750 an hour and get that attorney to help me compose a complaint and file it with the Attorney General's office and then file it with Superior Court. Would that contract that private contract that I've entered into with this attorney, would that contract be null and void as a consequence of this section?
Yeah, that's a good question. I don't have an answer to it. And the more broader point is I'm not dying on the hill of attorney's fees. I just don't want, I'm trying to avoid the situation of attorneys actively encouraging these suits versus a private individual trying to move forward on their own. But like I said, it's not the hill that I'm dying on. I was trying to, when I crafted this, I tried to go in and build the safeguards and stop abuse in advance, understanding that we are opening the gates.
Are there further questions from the committee? Representative Lane.
Well, at least you know I read it. Okay. Thanks for taking the question. In one of the, and it comes back to the question I had about whether you sue the city or the state. In one of these sections, the new sections D:4, it says files claimed against the state and its agent, but there's not a similar, so if you're bringing it against the city, would that fall under D5? So I'm just making sure it didn't, get left out. So it's on line 12, page 2, and then line 18.
So to your point, D5 says lines 19 and 20 says against another party. I
Yeah.
would assume that would, I would interpret that as meaning the towns. I certainly mean it. I certainly do mean it too.
Right.
So if you're asking what my intent is, yes, but I believe that covers it. Once again, I'm definitely open to changes. It's not in my way or the highway on the bill, but.
Okay. All right. Thank you.
Further questions from the committee? Seeing none, thank you very much, Representative, for your testimony. I have one individual who's requested to testify, Representative Horrigan. Thank you very much for being here today. You are recognized. Well, we'll leave it where he left it, and he'll hopefully be able to find it easily. Right.
Well, if he's like me, he has the ringer turned off all the time. So
Okay, well, thank you. Please
if you want to
proceed.
reach me on the phone, you have to leave me a Google voicemail. But anyway, so I'm Representative Timothy Horrigan from Stratford County District 10, which is the town of Durham. And I just feel I think this bill goes way too far. Well, first of all, I'm not going to say it's necessarily in the wrong committee, but they're putting it in a chapter of the law books, which would normally, the purview of the committee I belong to, judiciary, although I'm glad we have plenty of bills over there, so I'm just as happy they didn't send it to us, which is the law book about proceedings in special cases. So it's not in the election law book, but it is a election issue, so that part of it's fine. It looks like has a very expansive definition of person, which I think actually includes political subdivisions, which usually aren't considered persons in other areas of the law. So that's so allows just about anybody to sue just about anybody associated with elections. I think it's like it just goes very far. And with elections, in addition to the DOJ, and there's a election law. There is a department in the department. They used to be across the street, now up the road, which deals with election issues. And I found them very, very helpful, regardless of your political persuasion. If you believe there's an election law violation, and I actually, a few years ago, filed one against somebody, and I guess they did not prosecute the person, but I thought they were very helpful in regards to that. So this is in addition to the DOJ, who I think actually do a good job. Like whether or not there's also if it includes the if it affects the result of the election, there's also the Ballot Law Commission, which is part of the Secretary's of State's office, and they're pretty permissive in like who can file what. Although they're set up to make decisions quickly, and they're usually their priority is usually to make the decisions as non-disruptive as possible. But that is another avenue you can file if you have concerns about how if an election was handled improperly. And also, what was it? Oh, also, the one thing about the elections is elections are very time sensitive, especially if you have an issue with the primary. And I was just talking about about an hour ago, I was here talking about a ballot law commission proceeding, which is related to the primary. They have a very short turnaround time before they have to get to the general election. And even in the general election, there's not that much time between when the winner of the general election takes office. So that's one reason maybe not to send things to Superior Court and spend years, dealing with some dispute and possibly leaving an office vacant. Also, we have frequent elections. So even, if you think the wrong candidate loses the election because of a violation of RSA 659, there's another election coming up shortly. And also elections, just about all our elections have federal offices, at least most of our elections have federal office on them as well as state office. So you also have the option of seeking redress in the federal courts. Although, given what's happening in the federal government, I hate to rely too much on what the federal government will or will not be doing in the future. But you do have the option of filing in federal court. And so I would just say this bill is unnecessary. It goes too far, and there may be some legitimate concerns in there, but you should probably ITL it. And also, if you're swayed by what the representative from Goffstown said, and although I will admit, you're in kind of a tricky position because he's not just a member of the committee, but the chair. But he alluded to something that happened that involved an electioneering violation, and it might be useful if you think that's a compelling reason to go forward with the bill to maybe have some sort of work session and try to reach some sort of consensus about exactly what it is that happened to Representative Barry. Although, and of course, in all fairness, he probably wouldn't have wanted to sue anyway, even if this law was passed, because he actually won his election, so he wasn't really harmed. He may have been aggrieved by what happened. He may even have legitimate reasons to seek redress, but he in fact won, so he wasn't actually technically harmed by whatever it is that happened. But I will say, you might want to nail down exactly what that anecdote is and what the established facts are and what happened, which is not really clear from what he said. So anyway, I've gone over my 2 minutes already. So thank you for your patience. And so I urge you to ITL it, and I suppose you enjoy your lunch. Thanks.
Okay, thank you very much. Will you take questions from the
Sure,
committee?
yes.
Other questions from the committee? Seeing none, thank you very much for your testimony.
Thank you very much. Make sure he gets his phone. I'm sure he'll notice it's missing eventually, but
Yep.
get it to him sooner rather than later. Because
You bet.
I know I hate misplacing my phone.
Somebody
In
left
fact, there he
his,
is. Cool. Thanks.
somebody left his phone on the table there, Representative. All right, well, seeing no further requests to testify, Representative Guzovsky, could you get me the blue sheet, please? Oh, okay. Our soon-to-be chairman again. Yeah, we are. And Representative Newsom, if you could do me the favor again. Okay. I see 4 people testifying via the blue sheet against adopting this bill as law.
And online is in support 8, in opposition 259.
Thank you so much for reading that off for me. Okay, and with that, I am closing the public hearing for, hey, we're still in a meeting here. I'm closing the public hearing for HB 514. We will meet again at 1 p.m. to have several executive sessions. You may now speak as you wish.
Excuse me.
Hello, folks. Our chairman is unavoidably delayed due to backlogs in the cafeteria. Says he'll start back at 1:15. So I'm going to open the first executive session and recess it. So I'm opening the executive session on HB 365FN. We're going to recess it until 1:15. If he's not back, then we'll do the same thing again. So we are in recess till at least 1:15. Thank you. And judging by the number of empty seats, maybe that's just as well.
Okay, we're going to open up the notice executive session for the House Election Law Committee. And I'm going to get my notes out here. I don't know why I closed them. Okay, we'll just let's just start with the top. I'm going to open the executive session for House Bill 365 relative to proof of United States citizenship for voters, and I will make the motion of ought to pass. Is there a second?
I'll second it.
Representative Quayle seconds. Is there discussion on the motion of ought to pass on House Bill 365? Representative Lane?
In the subcommittee, we hadn't had a chance to fully vet this. And we were talking about requirements for citizenship and what would work. And our wonderful legislative assistant has been helping us in getting information. So there is some question about whether or not it's would pass legal muster because it has been challenged in other states and has been struck down. And is there another way to get proof of citizenship other than having us have to provide it to the government? The government, in most part, has proof. They either have our birth certificates, they have records of our passports, and they have records of real ID. So instead of putting it on us, the government already has a lot of this information, and why can't they provide it either to the Secretary of State or provide it to us directly to give, so that we don't have to, because one of the questions we came up with was, what is indigent? And we're going to take an affidavit that you're poor, but we won't take an affidavit that you are a citizen. It just didn't seem to make sense logically. So we were headed on talking about it. And so we're going to vote ITL just because we think a lot more work. And I think there are other ways to accomplish the goal that this bill wants to do. We could do it in a different way that does not put a burden on people, because trying to prove citizenship is expensive for people, and it takes months and months in some cases. So it doesn't seem right to require it, particularly for those who can't afford an extra $500 to get their citizenship papers. Thanks.
Okay. Further discussion on the bill? The reason we're moving on this bill while it's still in the subcommittee is it's an early bill. So we have to vote on it today because tomorrow, and I'll make that announcement once we get done with this vote. But these first three are early bills. So I will need those reports tonight. No exceptions, because those have to be reported out tomorrow. So anyways, we're on the motion of ought to pass on House Bill 365. Does any other member wish to speak? Hearing none, are you ready for the question? The clerk will call the roll on the motion of ought to pass on House Bill 365.
Representative Quayle.
Yes.
Representative Burnham, yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative Harvey Bolia.
Yes.
Representative C.
Yes.
Representative Gazowski.
Yes.
Representative Toner.
Yes.
Representative Alexander.
Yes.
Representative Lane.
No.
Representative Ward.
No.
Representative Gilmore.
No.
Representative Muirhead.
No.
Representative Bay.
No.
Representative Grill.
No.
Representative Wilhelm.
No.
Representative Newsom.
No.
Chairman Barry.
Chair votes yes. With that, the motion of ought to pass carries on a vote of 10-8. I'll be responsible for the majority report. Representative Lane, who will get the minority report? Excuse me. Representative Wood will be responsible for the majority report. I assume Representative Muirhead will be responsible for the minority report since he's flagging me. Okay, with that, we will close the executive session for House Bill 714. Reminder, those three bills are all early bills, so I need those reports tonight because they are due. I have to have them in tomorrow by noon, so I need to have them tonight because Lord knows what's going to happen when you have a 2-year-old at home. So next, we'll open the executive session for CACR 2 relating to the drawing of district boundaries, providing that no district boundaries shall be drawn in a way that favors or disfavors any political party or candidate. I will make the motion of inexpedient to legislate. Is there a second?
Second?
Is there any discussion on the motion of inexpedient to legislate on CACR 2? Representative Lane, you're recognized.
I realize that there's some issues with the way this was originally drafted, but I would like to have had the chance to fix some of the issues that were spotted. But I also just want to point out to everybody that this is one of the most often cited reforms and reasons for voters not liking our political system and not participating, because they do not think that we should be redistricting for ourselves, that we should, for our parties, we should be redistricting for our constituents. And so that's it.
Is there further discussion on the motion of any speech to legislate on CACR 2? The only comment that I will add is it's an inherently political process. It's a messy process. And the more you try to divorce it from what it actually is, the more it just becomes even worse, in my opinion. So I understand the points of it. I understand the argument for it. But when you look at it at the end of the day, somebody in a political position somewhere is making a decision about who's going to control this. So with that, if you're ready for the question, the clerk will call the roll on the motion of any expedient to legislate on CACR 2.
Representative Quayle,
Yes.
Representative Burnham, yes. Representative Weary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia,
Yes.
Representative C,
Yes.
Representative Gozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander,
Yes.
Representative Lane,
No.
Representative Ward,
No.
Representative Gilmore,
No.
Representative Muirhead,
No.
Representative Bay,
No.
Representative Grill,
No.
Representative Wilhelm, Representative Newsom,
Nope.
Chairman Barry,
Chair votes the yes. With that, the motion of any expedient to legislate on CACR 2 carries on a vote of 10 to 8. I'll be responsible for the majority report. Representative Lane, who will have the minority?
I think Russ, Representative Muirhead.
Okay, we will close the executive session on CACR 2. And we will open the executive session for House Bill 130, arrangement of candidates on primary election ballots. And I will recognize Representative Wood for a motion.
Yes, thank you, Mr. Chair. I'd like to move House Bill 130 to ITL.
Representative Wood moves in expedient to legislate on House Bill 130. Is there a second?
I'll second that.
Representative Gosowski seconds. Is there discussion on the motion of any expedient to legislate on House Bill 130? Yes, Representative.
Just curious, a quick reason for IT. I'd be grateful if someone offered a quick reason, just out of curiosity.
Someone is someone can if they wish. Representative Wood.
For the elections they were talking about, the primary for the state representative, I was doubting whether that first place position is as valid as this one person indicated. And also, it seems like we will be adding complication for the ballots being created. Some of the districts are a little crazy with the Flotero, so I just didn't see the advantage for that particular election, and that was what was spelled out in that. Yeah, you're welcome.
Further discussion on the motion of any expedient to legislate on House Bill 130? Hearing none, are you ready for the question? Clerk will call the roll.
sorry, I made a mistake. Okay, here we go. Representative Quayle,
Yes.
Representative Burnham, yes. Representative Weary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia,
Yes.
Representative C,
Yes.
Representative Gozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander, Representative Lane,
Yes.
Representative Ward, sorry.
Yes.
Sorry. Oh, I put on my glasses and I can't see. Representative Gilmore,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
Yes.
Chairman Barry,
Chair votes yes. With that, the motion of any expedient to legislate on House Bill 130 carries on a vote of 18 to 0. Is there any objection to this bill being placed on the consent calendar? Hearing none, the bill will be placed on consent calendar. Representative Wood, you will be responsible for the committee report. With that, we will close the executive session on House Bill 130. We'll open up the executive session for House Bill 154, enabling voters to request to have their ballots hand counted, and I will recognize Representative C for a motion.
I move with HB 154 be ought to pass.
Is there a second? Representative Weary seconds. We're on discussion on the motion of ought to pass on House Bill 154. Is there discussion on the motion?
This is just a.
Representative C is recognized.
Oh,
There you go.
I'm sorry. This is just a straightforward thing to show that voters do have the right to have their ballots hand counted.
Further discussion on the motion of ought to pass on House Bill 154? Don't worry. I'll add. I hope if this becomes law that less people will do it. Does that make sense? Like because they can, they won't. Because right now we see a lot of people doing like the write-in bubble or intentionally overvoting, basically forcing the issue. And I'm hoping that if voters see that they can do this, that they will just run their ballot through the machine because they have the option to. So that's my hope.
I do not have enough roll call.
We do not have enough roll call sheets. Okay.
I'll drag it out.
Of course. And we can always stand in recess for a minute.
Okay.
Yes, Representative Lane.
I guess my concern is that it's actually going to do the opposite, that more people are going to ask for it and it's going to delay the counting of votes. And hand counting has been shown to be less accurate than machine counting. So I am hoping that I am wrong in my concerns and we shall see.
Further discussion. I would actually echo part of that. Obviously, we disagree on the effect, but voters, I will issue a word of caution is when you do this, when you exercise this, when you do it either because you forced it or we're potentially going to enable you to do it, you're saying, I want somebody who's been up for 16 hours straight to pull out my ballot and read it amongst other ballots that are either put in that bin or had errors. And to Representative Lane's point, my experience in the recounts shows me that the machines are far more accurate than the people. And I think you have that right. But you kind of take your ballot into, you also have the right to suffer the consequences of someone unintentionally who has been up for 16 hours misinterpreting your intention on the ballot should there be an issue. I've never, when we do these recounts, I always help on my side with the recounts, and I always try to kind of counsel the candidates that are going through this. It's like when you have a machine town or machine voting location, you'll see small changes. You'll always see small changes because the people will fill out the ballot wrong and something will be off and something will change. You'll see small changes. And in hand count towns, you either see very little change, if any, or you see a massive move because something went horribly wrong. So you kind of take that. Anyways, now that we've delayed this long enough, yes, Representative Wood.
Thank you, Mr. Chair. You did bring something. Here's a chance for us to work as bipartisan on this. I was surprised how many people that I know actually think they have the right to do this. And that whole circumstance that happened really affected some people because they thought that something was taken away from them. I think what we can do as a bipartisan is convince people that the election, the ballots or the machines work. But I think they should have the right to make that decision. If they see something that bothers them, this allows them to take it to the moderator or to somebody else there and have it done the old-fashioned way. Thank you.
All right, Representative Gilmore.
Well, and for the last, I don't know, half dozen elections at least, they could just put it in the side machine and it's never been an issue. And there's other ballots that are, of course, are hand counted, Ucava and a couple others. So I don't really see what's a big deal here, but I thought everybody had that right already.
If it makes you feel any better, Representative Gilmore, I actually learned something almost every day we have a hearing or executive session. I learned something new about election laws, and I consider myself in the upper echelon of people who are informed about it. So, all right. Is there any other discussion on the motion of ought to pass on House Bill 154? Hearing none, are you ready for the question? The clerk will call the roll on the motion of ought to pass on House Bill 154.
Representative Quayle.
Yes.
Representative Burnham. Yes. Representative Wary.
Yes.
Representative Wood.
Yes.
Representative Harvey Bolia.
Yes.
Representative C.
Yes.
Representative Gozowski.
Yes.
Representative Toner.
Yes.
Representative Alexander.
Yes.
Representative Lane.
No.
Representative Ward.
No.
Representative Gilmore.
Yes.
Representative Muirhead.
Yes.
Representative Bay.
No.
Representative Grill.
Yes.
Representative Wilhelm.
No.
Representative Newsom,
No.
Chairman Barry.
Chair votes yes, and with that, the motion of ought to pass on House Bill 154 carries on a vote of 12 to 6. Representative C, you will be responsible for the majority report. Representative Lane, who will have our minority report?
Representative Ward.
Representative Ward will have the minority report. All right, with that,
What was the vote?
it was 12 to, I thought it was 12.
I have 14 to 4.
Yeah, you're right, I can't count. Let me just, well, hold on, we're gonna triple check here, because I thought I was counting along as I went along, but maybe I messed up. I didn't hear Representative. Hey, Representative Girl, how did you vote?
I voted yes.
Okay, I'm sorry, that's where I messed up. And Representative Newsom, he did vote. You voted no, right?
Oh, you voted no? I'm sorry. I
Okay,
have yes.
so
I've
we're,
gone back and forth.
it's all right. It's all right, because we're both wrong. You had 14, I had 12, and then the answer is 13. So with that, all right, so we'll try this again. With the motion on ought to pass carries on a vote. Hand counting, people. The motion of ought to pass carries on a vote of 13 to 5, with a cautionary tale about hand counting ballots. With that, we will close. God works in mysterious ways. We will close the executive session on House Bill 154.
Yeah, that's right, but I have a question about.
Oh, turn on your microphone if you're going to speak.
Oh, yes, if I can interrupt for a moment. HB 130, was that on the consent calendar or not?
HB 130.
That's an FN, so.
Yes, it's a negative motion. So it can
Okay.
go on the consent. It's because it's a negative motion, it can go on the consent calendar.
Want to make sure I got that right. Thank you.
This is the amendment for the next one.
Oh, okay, perfect.
Representative Quayle?
Oh.
Representative Quayle, do you have who made those motions? I kind of missed that when I was looking for my.
We have that. So 154, the motion of ought to pass was made by Representative C, and it was seconded by Representative Weary.
Thank you.
All right. And next up is going to be the ever recessed House Bill 158, which I'm recessing because I still have not gotten my amendment done. But maybe once we get through this, it's not an early bill, so we have time. So we're recessing 158. It always, as you know, at this point, I just include it because it makes me feel good. And now we will open up the executive session for House Bill 363, and I will recognize Representative Lane for a motion.
I'd like to move to amend.
Representative, well, first we have to make an
Well,
ought
I
to
have
pass
to open
motion.
it. You're right.
Yep.
I would like, I would like to move to ought to pass.
All right, Representative Lane moves ought to pass on House Bill 363. Is there a second? Representative Ward seconds. Representative Lane, do you have an amendment?
Yes, I do. Thanks. I handed out an amendment. The purpose of this amendment was to address some of the comments that were made at the public hearing. So the section that was addressing compactness has been taken out so that there are now 6 requirements instead of 5. And then on line 15 and 16, I've added in school districts as a metric for communities of interest. Otherwise, it's the same.
Okay, we're on discussion on Amendment 2025-0682H on House Bill 363. I'm sorry, did you move the amendment? There was a second by Representative Ward, correct? We did that? All right, just making sure, because I can't count, so. Just trust but verify. So we're on discussion of the amendment we're on discussion of Amendment 2025-0682H, moved by Representative Lane. Is there further discussion on the amendment? Our rules allow us to take up amendments by a voice vote. All those in favor of adopting the amendment say aye. Aye. All opposed say no. The ayes have it. Representative Lane, would you like to make a new motion?
Yes, I would like to move ought to pass on HB 363 as amended by, oh boy. 2025-0682H.
Representative Lane moves ought to pass this amendment on House Bill 363 with Amendment 2025-0682H. Is there a second? Uh-oh. Okay. Representative Newsom seconds. Woo! Is there discussion on the motion of ought to pass as amended? Hearing none, the clerk will call the roll. You ready for the question? The clerk will call the roll. There you go.
Representative Quayle,
No.
Representative Burnham, no. Representative Wary,
No.
Representative Wood,
No.
Representative Harvey Bolia,
No.
Representative C,
No.
Representative Gozowski,
No.
Representative Toner,
No.
Representative Lane,
Yes.
I'm sorry, go back to Representative Alexander.
No.
Sorry about that. Representative Ward,
Yes.
Representative Gilmore,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
Yes.
Chairman Barry.
Chair votes no. With that, the motion of ought to pass as amended on House Bill 363 fails on a vote of 8 to 10. I will make the motion of inexpedient to legislate on House Bill 363. Is there a second? Representative Toner seconds. Is there discussion on the motion of inexpedient to legislate? Hearing none, are you ready for the question?
Can I ask who seconded?
That'd be Representative Toner.
Thank you.
And the clerk will call, hearing none, the clerk will call the roll on the motion of inexpedient to legislate on House Bill 363.
Representative Quayle,
Yes.
Representative Burnham, yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia,
Yes.
Representative C,
Yes.
Representative Gozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander.
Yes.
Representative Lane. That's okay.
No. I'm not going to trust anything. No.
I'm going to make sure I get the right column too. Representative Ward,
No.
Representative Gilmore,
No.
Representative Muirhead.
No.
Representative Bay,
No.
Representative Grill,
No.
Representative Wilhelm.
No.
Representative Newsom,
No.
Chairman Barry.
Chair votes yes, and with that, the motion of inexpedient to legislate on House Bill 363 carries on a vote of 10 to 8. I'll be responsible for the majority report. Representative Lane, who will be responsible for the minority report?
I am, and everyone can now see how poorly I multitask.
That's all right. You have a chair with a bad ADHD, so I'm like live in multitasking land all day in my brain, so it's not easy to keep up. But you just don't ask me to remember something. With that, we will close the executive session on House Bill 363. House Bills 356 and 590 are going to be recessed to bring a package forward. So we're going to open up the executive session on House Bill 367, changing the method of adopting partisan town elections to be the same as rescinding partisan town elections. And I recognize Representative Weary for a motion.
I'd like to make a motion ought to pass.
Representative Weary moves ought to pass. Is there a second?
Second.
Representative Harvey Bolia seconds. I know we don't normally talk much during execs, but there was a request to actually explain what was going on here because there was general interest. So I would highly recommend that the member who made the motion of ought to pass explain why, because this will be one of the times in election law where you may pick up votes with your explanation.
Thank you, Mr. Chair. So this is really just leveling the playing field. You can rescind partisan town elections. So you have the option of moving toward partisan town elections. And this just makes the process for adopting them the same as rescinding them. So there's currently a method for rescinding partisan town elections. This just makes adopting it to be equivalent, and it levels the playing field in terms of how a town can adopt this approach.
Yes, Representative Lane, recognized.
So how in the past have they adopted it if they didn't have a way to do it?
There hasn't been many towns that have adopted this, but I believe that the purpose of the legislation is to make the method of adoption is the same as the method of rescinding it. So it comes in one way and it comes out the same way, to put it on the same I don't want to say the same playing field, but use the same mechanism But to answer your question was, how have they done in the past? The answer is they haven't much. Yeah, unless that was the point you were trying to evoke. Okay, excellent. Yes, I figured that's where you were going with that, and I just thought I would indulge you. So, they used to do partisan elections. I was looking through some old Manchester election history, and they used to have partisan elections. And it was just kind of wild looking through local election results and seeing partisan. And at some point, somebody made the decision to move away from it. Generally speaking, we have these bills on partisanship, and I kind of more globally speaking, I reject the notion that these are nonpartisan elections. I understand that they're not listed on the ballot, but if we're all going to sit here and pretend like the parties aren't engaging at this level at this point, I mean, I lived in Manchester for 12 years. I will tell you right now, the Manchester Democrat Committee and the Manchester Republican Committee were both heavily involved in those, quote, nonpartisan elections. So I generally think more globally, if you at least disclose what party someone is a part of, I think you're going to see turnout in these horribly low turnout elections go up, because many voters are not engaged at the minutia level. Most people, when they move to town, don't know who's running, and the only piece of information that they might have is partisanship. And for some reason, we have decided to deny people that indicator. But a party is not a brand loyalty for life. It's just more of a statement about who do you more globally identify with. I'm a Republican, but I don't identify with every plank of the Republican platform. I co-sponsor the legalization of marijuana. I've been a longtime supporter of marriage equality, but I'm very conservative on government. So I tend to, those other things, I tend to identify more with the Republicans than not. So somebody who knows nothing about me, if they want to vote for the candidate of limited government, that's the party, they're going to vote Republican. If they don't, they're going to vote Democrat. And I think when you deny the voter that piece of information, I think it actually decreases their turnout. I think it decreases their knowledge when they're making a decision. And the partisanship already exists. It's just we just choose to pretend like it doesn't. Anyways, that's my rant. Anyone else wish to speak to House Bill 356? Representative Weary.
So the RSA that addresses special provisions for partisan ballot systems begins in 669-37 and carries on for several pages after that. So if people are particularly interested in finding out all the specific details of that area of the RSAs, that is the area to be looking at.
All right. Further discussion on the motion of ought to pass on House Bill 367. Representative Gilmore.
Thank you. The question I have is, this is for town elections. Dover's a city. Dover, I believe, was the first city in the state that went nonpartisan. That was well over 50 years ago. Does this affect cities? Could a city go back to nonpartisan, but can't under this? That's my question.
That's a great question. Let's take a look. I'm just reading it real fast. That's a great question, though. Procedure and outline is 699. If anybody beats me to it, feel free to jump in.
Says any town. Line 2 on page 2. Any town may vote to adopt.
Yeah, 669-12.
The change refers only to towns.
Yes, but there is a method for partisan city chart. I mean, the cities operate under a different system, and I'm trying to remember where that is. I think to answer Representative Gilmore's question, I think on face value it only applies to towns.
That's what the bill says.
But I do think that's more of a, I'm going to write that down because that's actually, I want to review that statute for cities in general.
The city operates under the city charter, of course, and I think it's probably in there that we'd have to do it. But again, I don't know what the process is, though it was a city charter.
Yeah, and the name of chapter 669 is town elections.
Correct. Elective districts. Yeah, that's a great I'm gonna have to do some research, so thank you. I was gonna have to go and I said I learn every time. All right, further discussion on the motion of ought to pass on House Bill 367. Representative Newsom, you're recognized.
Thank you. Just a quick question. Does this affect whether it's on the business meeting or the ballot?
So this is on the partisan. This is on the partisan official ballot system. So my guess is would it be it wouldn't.
But
it's
I
on
guess which way is it before the legislation?
six.
Does that move it from one to the other is the question.
I don't believe it's not moving anything. It's adding. It's adding to 669.12 and taking away from the. It's editing 12 and 13, so it's not really moving. I guess I don't understand the question. I'm sorry.
Well, I guess before the, like today, would it be done during the business meeting or the balloting?
Oh, you're asking how it would be done today.
Yes.
Okay.
And does this change that?
So
Whether from the business meeting or the ballot system?
Yep. So currently, I'll read 1612. Any town may vote to adopt the partisan official ballot system for election of town officers under an article in the warrant for any town meeting and may rescind such action in like manner. The partisan ballot system shall not be in effect until town election first following the town meeting at which such system is adopted. A plurality shall elect in towns using the partisan ballot system. Did I sufficiently dodge the question?
You dodged it very well, but then I guess it begs a follow-up question is that the bill says that it is making the adoption and the rescission the same, yet
Yeah, what a messy RSA.
they're taking rescind such action in like manner.
Yeah, what a
So
messy
we're already there.
But why even have the?
And that's I guess where my additional confusion is coming from. And
It's a fair point.
If I may, Mr. Chair,
Go ahead. Yeah.
I think in 669 where it talks about in any town in which, so 3 or 4 lines down in 669.13 talks about in any town in which the partisan ballot system is in effect and which has a population according to most
Line
recent
20.
federal,
Yeah.
right? So,
It's line 20. It's struck, yeah. So
Yeah,
can
so-
you just strike that and then, do you need this because it's already in here? That was kind of where I was headed, like.
Yeah, that's actually. I think Representative Lane's making a good point. Do you even need the rest of that language because it already says?
It's actually.
if it says it, oh,
I don't want to steal Representative Newsom's thunder here.
No. I tell you what. Let's recess this bill.
okay.
I think that there's some. I think it. I told you discussions was needed. I wasn't holding it back. I was like, you're gonna want to talk about this one.
Okay, why didn't people do
Does this mean we're recessing with a pending motion of OT?
Yeah. Oh, I should say, yeah. When we come back, we will be on the motion of ought to pass. So just like when we come back, like we're just immediately back to that. All right. So now that we've burned up some brain cells there,
Okay.
we'll move to. We'll open up the executive session for House Bill 481 relative to moving the state primary date. I will move that the bill be ought to pass. Is there a second?
Second?
Representative Wood seconds. This is the June bill for those trying to keep track at home. This is the June bill. Is there discussion on the motion of ought to pass? And no, I don't feel the need to make another speech. So tell me why I'm wrong. All right. I know you're devastated. Hearing none, are you ready for the question on the motion of ought to pass on House Bill 481? The clerk will call the roll on the motion of ought to pass.
Representative Quayle,
Yes.
Representative Burnham, yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia,
Yes.
Representative C,
Yes.
Representative Kozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander,
Yes.
Representative Lane,
Yes.
Representative Ward,
No.
Representative Gilmore,
No.
Representative Muirhead,
Yes.
Representative Bay,
No.
Representative Grill,
No.
Representative Wilhelm,
No.
Representative Newsom,
yes.
Chairman Barry.
Chair enthusiastically votes yes. You now have to do math. Another hand count.
13-5.
The motion of ought to pass on House Bill 481 will carry out on a passes on a vote of 13-5, and I will take care of the majority report, and I appreciate the bipartisan camaraderie on that one. I really do. We'll close the 13-5. Oh, I'm sorry. Yeah, it's their minority report. I apologize. Representative Grill, minority
yes.
report.
Yeah,
My apologies.
Representative Grill.
My apologies. All right, with that, we will close the executive session on House Bill 481. I got so excited. I just,
Yeah, I understand.
oh, and there's the warning. And there's the warning. And there's the warning. Open up the executive session for House Bill 481 relative to moving the state primary date. Sorry, we just did 481. Sorry, excited. House Bill 408, moving the state primary date to the fourth Tuesday in August, and I will make the motion of inexpedient to legislate on that one. Is there a second?
Second.
Is there a discussion on the motion of inexpedient to legislate on House Bill 408, the August bill? The August. It's like how I use the negative, just the negative kind of present in August. All right. Hearing none, the clerk will call the roll on the motion of inexpedient to legislate on House Bill 408.
Representative Quayle,
Yes.
Representative Burnham, yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia, Representative C,
Yes.
Representative Gozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander,
Yes.
Representative Lane,
No.
Representative Ward,
No.
Representative Gilmore,
No.
Representative Muirhead,
No.
Representative Bay,
No.
Representative Grill,
No.
Representative Wilhelm,
No.
Representative Newsom,
No.
Chairman Barry.
Chair votes yes. With that, the motion of inexpedient to legislate on House Bill 408 carries on a vote of 10-8. I'll be responsible for the majority report. Who is responsible for the minority report?
Representative Grill.
Oh, I thought you said Representative Grill, so she's going to do both of them. It's just kind of stand up for both. We're not September forever. No, it's Representative Wilhelm for the minority report. After I will eagerly await. With that, we will close the executive session on House Bill 408. And Representative C, is your amendment ready for 151? I just need to know if I need to open it or just recess it. Is it ready?
That was the amendment we had already.
Oh, that's right. Okay, so we already have it. All right, so we'll open up the executive session for House Bill 151 relative to the term of supervisors of the checklist. I'll recognize Representative C for a motion.
I move ought to pass.
Representative C moves ought to pass on House Bill 151. Is there a second? Representative Weary seconds. Is there an amendment to present?
Yes, amendment 0580.
Do we have copies of that amendment?
We were given that on, during the public hearing.
Okay. I don't want to vote on the amendment if it's not directly in front of the members. I don't think that's fair. Also, I don't want to vote on it without it being in front of me. Let's put in a request. Mr. Allen, can you find that amendment, get us copies? So I'm sorry, you're just here. I apologize. I know it's not your job, but thank you so much. So we will try to come back to this today, but I don't think it's fair to vote on an amendment when it's not in front of you. Oh, he gone. He gone. All right, so we'll recess it. We'll come back today, and then we will open up the executive session for House Bill 600, enabling ranked choice voting. I will recognize Representative Harvey Bolia for the purpose of a motion.
I make a motion of ITL, Mr. Chair, on House Bill 600. FM.
Representative Bolia moves inexpedient to legislate on House Bill 600. Is there a second?
I second it.
Representative Quayle seconds it. We're now in discussion on the motion of inexpedient to legislate on House Bill 600. Representative Wilhelm is recognized.
Thank you, Chairman. I am going to vote against the ITL motion, ranked choice voting. It's a widely accepted, tested, and proven method of voting. This is an enabling bill. It allows municipalities to make the decision that's right for their communities. Won't cost taxpayers anything. In fact, it may save some municipalities. I think we've seen across the country that it's, easy to understand, easy to administer, and it really offers an opportunity to provide really a chance to give voters more choices. Would improve the quality of campaigning, would improve the tenor of campaigns, which I think Granite Staters deserve, if their municipality decides to go with it. So it's a local control issue, and I think we should empower our municipalities to make the best decisions for them. Thanks.
Representative Harvey Boley is recognized.
Thank you, Mr. Chair. Real quick, I know ranked choice, this bill promised a lot of things, but there are three main things that are going against it. And one, it threatens fast and accurate ballot counting. It produces slow results and more irregularities. It has technical problems, which I'm aware of, working in the industry. There's at least 3 states that I saw that had technical software issues or hardware issues regarding the system. Number 2, it diminishes voter confidence. It's overly complicated. It is confusing. It requires voters to make decisions on all the candidates, which a lot of voters don't. And 3, the worst thing about this is it leads to gamesmanship in voting. Thank you.
Further discussion, Representative Gilmore is recognized.
Well, for all that you just said, it seems to be very popular in the states in which it exists. It seems to be very popular in the countries in which it exists. And the person with the highest votes actually gets a plurality, is the winner. So I'm all in favor of it.
Further discussion on the motion of inexpedient legislation on House Bill 600. Hearing none, you ready for the question? Clerk will call the roll on the motion of inexpedient to legislate.
Representative Quayle,
Yes.
Representative Burnham, yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia. Yes. Representative C,
Yes.
Representative Kozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander.
Yes.
Representative Lane,
No.
Representative Ward,
No.
Representative Gilmore.
No.
Representative Muirhead. No. Representative Bay,
No.
Representative Grill,
No.
Representative Wilhelm,
No.
Representative Newsom,
Nope.
Chairman Barry.
Chair votes yes. With that, the motion of inexpedient to legislate carries on a vote of 10 to 8. Representative Harvey Bolia will be responsible for the majority report. Representative Lane, who will have our minority report?
Representative Wilhelm.
Representative Wilhelm will have our minority report. With that, we will close the executive session on House Bill 600. We now have the amendment for House Bill 151. I'd like to thank our wonderful legislative staff for moving so quickly on that. Thank you. It's coming around. So we are going to reopen the executive session. I recognize Representative C for a motion to move an amendment.
I'll wait for it to get around. All right. I move the amendment 0580H.
Representative C moves amendment 2025-0580H to House Bill 151. Is there a second? Representative Weary seconds. We are now on discussion of the amendment. Is there discussion on the amendment? Representative C is recognized.
The amendment just simply takes care of either an oversight or a typo. Because it was going to 3-year terms instead of 6-year terms, that meant that elections had to occur in every year rather than just even numbered years.
Is there further discussion on the amendment? All right. Our rules allow us to adopt amendments by voice vote. All in favor of adopting amendment 2025-0580H to House Bill 151 say aye. Aye. All opposed say nay. The ayes have it. The amendment is adopted. Representative C is recognized for a motion.
I move ought to pass with amendment.
Representative C moves ought to pass as amended on House Bill 151 with Amendment 2025-0580H. Is there a second? Representative Weary seconds. We're now in discussion on the motion of ought to pass as amended. Is there discussion on the motion of ought to pass as amended? Hearing none, are you ready for the question? The clerk will call the roll on the motion of ought to pass as amendment on House Bill 151 with Amendment 2025-0580H.
Representative Quayle,
Yes.
Representative Burnham, yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia,
Yes.
Representative C,
Yes.
Representative Gozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander, Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Gilmore,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
Yes.
Chairman Barry.
Chair votes yes. With that, the motion of ought to pass as amended carries on a vote of 18-0. Representative C, you'll be responsible for the committee report. Is there any objection to this bill being placed on the consent calendar? Hearing none, the bill will be placed on the consent calendar. With that, we will close the executive session on House Bill 151, and we will open up the executive session on House Bill 412 is going to be recessed as part of those partisan school bills. We're going to open up the executive session for House Bill 429 relative to amending the term of the length of county commissioners. Representative Wood is recognized for a motion.
Yeah. I'm moving HB 429 for ITL, please.
Representative Wood moves inexpedient to legislate on House Bill 429. Is there a second?
Second.
Representative Toner seconds. More discussion on the motion of inexpedient to legislate on House Bill 429. Is there any discussion? Hearing none, are you ready for the question? The clerk will call the roll on the motion of inexpedient to legislate on House Bill 429 when she is so ready.
Thank you for your patience. Representative Quayle,
Yes.
Representative Burnham, yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia,
Yes.
Representative C,
Yes.
Representative Gozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander, Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Gilmore,
Yes.
Representative Muirhead,
Yes.
Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
Yes.
and Chairman Barry.
Chair votes yes. Without the motion of inexpedient to legislate on House Bill 429 carries on a vote of 18-0. Is there any objection to this bill being placed on consent calendar? Hearing none, the bill will be placed on consent calendar. Representative Wood, you'll be responsible for the committee report. With that, we will close the executive session on House Bill 429, and we will open the executive session for House Bill 333, requiring moderators to designate a space for electioneering at polling places and provide a schematic thereof. And I recognize Representative Harvey Bolia for a motion.
Thank you, Mr. Chair. I make a motion of ITL on House Bill 333.
Representative Harvey Bolia moves inexpedient to legislate on House Bill 333. Is there a second?
Second.
Representative Wood seconds. Is there discussion on the motion of inexpedient to legislate on House Bill 333? Hearing none, are you ready for the question? The clerk will call the roll on the motion of inexpedient to legislate on House Bill 333 when she is ready.
Representative Quayle,
Yes.
Representative Burnham, yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia,
Yes.
Representative C,
Yes.
Representative Gozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander, Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Gilmore,
Yes.
Representative Muirhead, Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
Yes.
Chairman Barry.
Chair votes yes, and with that, the motion of inexpedient to legislate on House Bill 333 carries on a vote of 18-0. Is there any objection to this bill being placed on the consent calendar? Hearing none, the bill will be placed on consent calendar. Representative Harley Bullia, you will be responsible for the committee report. We'll close the executive session on House Bill 333. House Bill 395 is being recessed. House Bill 409 was withdrawn. I apologize for noticing it. So we're not going to take it up. It's on the calendar for Thursday on the withdrawn calendar, so we're not taking it up. House Bill, I will open the executive session for House Bill 220, closing the presidential or state primaries of political parties. I will make the motion of inexpedient to legislate. Is there a second? We'll take the second from Representative Ward. We'll go bipartisan. Word? I said word.
Sorry, no,
It's
I'm
okay.
just behind.
Oh, it's okay. No worries.
220.
Yep.
And who did the motion?
I did. Yep. I don't need to give my speech again. I gave it last time. It's the same bill. Is there any discussion on the motion of inexpedient to legislate on House Bill 220? Hearing none, the clerk will call the roll on the motion of inexpedient to legislate when she is ready.
Representative Quayle,
Yes.
Representative Burnham, yes. Representative Wary,
Yes.
Representative Wood,
Yes.
Representative Harvey Bolia, Representative C,
Yes.
Representative Gozowski,
Yes.
Representative Toner,
Yes.
Representative Alexander, Representative Lane,
Yes.
Representative Ward,
Yes.
Representative Gilmore,
Yes.
Representative Muirhead, Representative Bay,
Yes.
Representative Grill,
Yes.
Representative Wilhelm,
Yes.
Representative Newsom,
Yes.
Chairman Barry.
Chair votes yes. With that, the motion of inexpedient to legislate carries on a vote of 18-0. Is there any objection to this bill being placed on the consent calendar? Hearing none, the bill will be placed on the consent calendar. I will be responsible for the committee report. We have no other bills today. We're going to close the executive session for 220. We have no other bills today. A reminder, 365, 521, and 714. I need those reports tonight. Everything else, we're not going to see these bills for a couple, so it'd be nice to get them in. We can get them up. But with that, I'll see you guys on Thursday. We will have executive session next week. It will only be executive session. We have no more hearings. We actually did our last hearing today. So yay us. 70. We have. I don't think yay for us. 75 bills. We got through all of them. Thank you. I felt like it was a monumental task, but I guess not. So we will have it. I haven't quite decided on the time yet. So before everybody goes, it is town meeting day. We're only doing executive session. Is there a preferred time? We don't have to meet at 10 a.m. But is there a preferred time? Do we just want to meet at 10 a.m. anyways and get it done and be done with? Or do you want to go later in the day? Does anybody have a strong opinion? Meeting be done with. All right, 10 a.m. next Tuesday for executive session. That'll be similar to this. There'll be like 30 some odd bills on it. All right, I will see you guys I'll see you on Thursday. I'll see you again on Tuesday.